Hi guys. So we have Lively's memorandum for her request for fees. Um, you're gonna be annoyed. I'm just gonna say that. So you are gonna be incredibly pissed off with this. I am. Um, there is quite a lot though to go through. I mean, there's not a single invoice attached to any of this to support what she's claiming, but we do have a memorandum which I'm going to cover in this video. Then I'm going to do another video with Ezra's declaration, and then another video with Gottlieb's declaration. I'm not going to bother with the other ones because their declarations is basically, look how amazing I am, and look at all my achievements, and it's just like 15 to 20 pages of them basically, talking about how great they are at their job. And I don't think anyone's really interested in that. So, if I start with the memorandum here, the next one's going to be Ezra. That's going to be quite an interesting video. That's going to be interesting because she massively contradicts herself, and she does try to pull a fast one as well, which I've already clocked. I knew she was going to. My theory was that they were just going to, I don't know, maybe that they had Blake Lively and Ryan Reynolds down as joint clients and they just removed Ryan Reynolds' name. Because we're never going to know, really. We're not. We're not going to get to see his accounts to verify that they are definitely just related to Blake Lively. It does say in the declaration, you know, we had both clients, but the fees we're seeking are only in relation to Miss Lively. I don't believe that. For the amount of fees they're looking for, I don't believe it. I don't like saying that either. I don't like saying that, and a lawyer is not being honest about something, but I cannot believe it. And I still think that there is a very all likelihood, maybe not everything, but I do think that they have kind of merged some of the records from Reynolds into Lively's because it's going to be impossible to prove otherwise. But and the reason I have actually really kind of hardened on that opinion is because Ezra Hudson tries to pull a fast one, and I hope Wayfarer cotton onto it. But I will show you that if it comes up in this memorandum because I haven't read it yet. But if it does come up, I will show you. If not, it definitely comes up in her declaration, and I will show you there. Okay. So let's go through this memorandum. I am stuffed up with hay fever today. There's always something. But this is actually not long at all. The declarations are actually longer, if you can believe it. Okay, so introduction. Now this is going to be basically a PR hit piece, right? All I've done is kind of read the first paragraph and I'm already like, oh, for fuck's sake. So just to pre-warn everyone, before this litigation began, Steve Saritz, the billionaire financier of Wayfarer Studios, and Justin Baldoni threatened that if Blake Lively ever crossed the line, he would use his vast personal fortune to destroy Lively and her husband. See, it's still and her husband, even though there was no mention of Ryan Reynolds. And her husband, comparing his plan to a holy war. The Wayfarer parties made good on that threat just days after Lively filed her administrative complaint for sexual harassment and retaliation with the California Civil Rights Department. Claims they have now admitted were protected activity that deserved to be heard by filing a frivolous, baseless, and retaliatory $400 million defamation lawsuit designed to sue Lively into oblivion. This gross abuse of the legal system was not meant to win in court. Its aim was to retaliate against Lively by falsely branding her a liar, intimidating witnesses. I can't believe she's actually suggested she's talking about intimidating witnesses, and she subpoenaed 107 people, including me. Oh. And the intimidating witnesses and the media, and discouraging others from speaking out. The Wayfarer parties filed first in California state court against the New York Times, withdrew it, refiled in federal court, and then amended for no reason other than seeking publicity designed to impose maximum harm on Lively. Now, that is absolutely not true. Wayfarer amended that to include the metadata, which showed that Lively colluded with the New York Times. Then, after they vowed in the media that they would amend their complaint following this court's dismissal of their entire complaint, they quickly abandoned their lawsuit. The Wayfarer parties employed scorched earth litigation tactics designed to drain Lively's resources, including a near-daily press campaign. What? Promoting their sham lawsuit. Oh my god, is she seriously accusing someone of filing a sham lawsuit? Wow. Let me just... I have to just memorialize that. Yeah, that's just wild. Including a near daily press campaign promoting their sham lawsuit, propounding expansive and irrelevant discovery demands, obstructing discovery directed at them and affiliated third parties, and forcing Lively to seek frequent relief from the court to rein in their abusive docket filings. The Wayfarer parties chose to bring this retaliatory action in this court under California law, despite California Civil Code Section 47.1's robust fee and cost shifting provisions, and readily available public information regarding the rates charged by the law firms they knew would defend Lively. They could have ended it and offered to reimburse Lively at any time. Having refused to do so, they should be ordered to reimburse Lively for all of the costs, attorney's fees, and expenses they improperly forced her to incur. Now, that is not the purpose of the fee shifting provision under Section 47.1. It is supposed to be limited to successfully defending the action, the defamation action. Not everything else. But Lively actually goes much further than that. She is attempting to recover much more than just the defamation defense. Okay. Relevant background. On January 16th, 2025, the Wayfarer parties filed their $400 million retaliatory lawsuit against Lively and others, amending it on January 31st, 2025. An obvious PR tool filed for no conceivable legal reason before any responsive pleading or deadline to amend, the 391 paragraph first amended complaint and 168 page Exhibit A was an unhinged rant that attempted to brand Lively falsely, no, not falsely, as a liar. The Wayfarer parties sensationalized their lawsuit by launching and promoting a website. At the inception of the litigation on January 30th, 2025, the court determined that the Wayfarer action and Lively's affirmative case involved common questions of law and fact and consolidated the cases into a single action. As this court acknowledged throughout the litigation, the parties engaged in an extensive and fiercely contested discovery process. At every turn, discovery was met with extreme resistance by the Wayfarer parties, who failed to produce documents improperly invoked attorney-client privilege, and or destroyed relevant evidence. I've seen no evidence at all that they destroyed relevant evidence. She is just... Yes, she filed for spoliation sanctions. We never did get a ruling on that. Why? Because she settled her case. This required Lively to file over 15 discovery-related motions to compel during the course of these actions, 5 of which were prior to the deadline for the Wayfarer parties to amend their complaint. The Wayfarer parties also abused the court's docket to smear both Lively and her counsel, leading the court to warn that future misuse may be met with sanctions. That is referring to the motion to strike, and that is referring to Taylor Swift, not Blake Lively. On March 20th, 2025, Lively moved to dismiss the first amended complaint. On June 9th, 2025, the court dismissed the first amended complaint in its entirety, criticising it for lacking clarity as to the boundaries of claims and for relying on conclusory and often dramatised allegations. Given the baseless nature of their claims, Lively served 5 of the Wayfarer parties with Rule 11 safe harbour letters and demanded that they withdraw 6 of the 7 claims asserted against her. In response to her subsequent Rule 11 motion, the Rule 11 plaintiffs did not even attempt to defend the factual or legal merits of their claims. On March 27th, 2026, the court granted Lively's Rule 11 motion, concluding that there was no conceivable basis to assert 5 out of the 7 claims against Lively, and reprimanding the Wayfarer party's counsel for making claims that were legally frivolous and factually baseless. On September 8th, 2025, Lively moved for an award of attorney's fees, treble damages and punitive damages pursuant to Section 47.1. On June 12th, 2025, the court granted the 47.1 motion, limited to attorney's fees. Finding that Lively 1 made the statements that come within the purview of Section 47.1, meaning she had a reasonable basis for making claims of sexual harassment and retaliation and related claims. 2, prevailed on her defence, and 3, there is no evidence Lively made her statements with malice. Argument. The Wayfarer parties are liable for Lively's attorney's fees and costs. Section 47.1 provides that a prevailing defendant in any defamation action, so she knows this, brought against that defendant for making a communication without malice that is privileged under this section shall be entitled to their reasonable attorney's fees and costs for successfully defending themselves in the litigation. Accordingly, Lively seeks, wait for it, $8,035,040.88 in fees and costs for her successful litigation defence. As reflected in Exhibit B to the declaration of Diana Cantor, whose declaration is not on the docket, by the way. There is no declaration from anyone called Diana Cantor. This figure represents the expenses incurred and work performed by Lively's counsel to that end, specifically the fees and costs that relate to 1. Motion practice associated with the Wayfarer action, including but not limited to the prevailing motion to dismiss, then Rule 11 motion and motions to compel. And I am going to stop there because I said if an opportunity come up for this, I would bring it. So here we are. I'm going to bring it. This is the order on Rule 11. Okay, so this is from Judge Lyman. Now, I will just go up, actually, just to show you that this is the memorandum on order. Judge Lewis Lyman filed on the 27th of March, 2026, right? And as you can see, the motions of Lively and Reynolds under Rule 11 is granted in part and denied in part. So ordered Lewis Lyman. And I've highlighted for you this specific section, right? Now, bear in mind, she is trying to seek recovery of attorney's fees under Section 47.1 for this Rule 11 motion. She already did that in the Rule 11 motion, she sought attorney's fees. Lyman said, the court is authorised to impose monetary sanctions, including a penalty or attorney's fees for such conduct. So he acknowledged the court had the power to give her attorney's fees. In this case, however, there is no basis to believe that the allegation of the sanctionable claims imposed any great burden on Lively and Reynolds beyond the burden that they faced to address the claims which are not sanctionable. The sanctionable claims did not place any burden on the court. Accordingly, the court limits the Rule 11 sanction to a reprimand of Lina Friedman and Mr. Selig and their respective firms for violating Rule 11. Okay, so she already asked for it and was told no by Judge Lyman. And there is something else as well I'm going to show. Where is it? I just want to just check 1 sec. No, I can't find it. But anyway, so again, you know, she is requesting attorney's fees and costs for a motion where she has already been denied those attorney's fees and costs. That is what I was referring to, where I'm like, I don't like to suggest that an attorney is being dishonest, but I find that dishonest. I do. Okay. 2. Right, so yeah, including but not limited to the prevailing motion to dismiss, then Rule 11, and motions to compel. 2, work performed associated with the consolidated action as a whole. Right, again, it should not be part of that at all. Including discovery through the deadline for the Wayfarer parties to amend their pleading that was relevant to both actions. And 3, Liability's 47.1 motion, including this application. So I said this would come. I said, you know, basically, she'll be claiming for the defense. She should be claiming for the defense and for the motion to kind of, you know, request the fees under section 47.1 and the whole, this what we're doing here, basically. You know, Judge, I want to recover section 47.1 and pursuing that. Yes, she should recover that. She should also get to recover this, you know, for her putting forth her request for fees here. I do not agree that she should be seeking, definitely shouldn't be seeking it on the Rule 11 motion, nor should she be getting anything from motions to compel, right? Because that's discovery. Nor should she be getting anything where her own case would have needed to file whatever it is, so discovery requests and all. Her own case would have needed it. So that is not, in my opinion, a reasonable cost then to dump on Wayfarer just because she's got this. Because she needed it for her own case. So she would have done it anyway, regardless of Wayfarer's complaint. So, I mean, to summarise where we are so far, Lively is asking for everything, including the kitchen sink. And, you know, she's going to throw in this entire PR hit piece to rehabilitate her image while she's at it. Okay, so she argues next, Section 47.1 does not permit apportionment of defence fees and costs. It also doesn't say you can't apportion. It says reasonable. Ergo, there are things that can be denied. Section 47.1 does not limit the recovery of reasonable attorney's fees and costs to the successful defence of a particular claim, i.e. defamation. I'm gonna have a look at the actual wording again. I always find it helpful. She may have a point, but you know. Okay. Okay, let's share this. So, yes and no. I don't know if I can. Can I? I don't think I can highlight it. Okay, that's the best I can do. Okay, so a prevailing defendant in any defamation action. It's quite specific. Defamation action. It does specify defamation. I had Wayfarer not included a cause of action for defamation, if they'd left out defamation entirely and just used, say, false light, right? Then they would not even be on the hook for Section 47.1 fees. That's how specific defamation is to this. Okay, the only reason that Section 47.1 has even come into play here is because one of the causes of action against Lively was defamation. So I don't agree with Lively's argument here. I think actually it kind of implies that defamation is very specific. So she is saying, if I just go back to it, she's saying Section 47.1 does not limit the recovery of reasonable attorney's fees and costs to the successful defence of a particular claim, i.e. defamation. I'm reading it differently. I'm seeing here a prevailing defendant in any defamation action, a specific action, brought against that defendant for making a communication that is privileged under this section shall be entitled to their reasonable attorney's fees and costs for successfully defending themselves in the litigation. And I think it does specify defamation, because it would not even be invoked for any other cause of action. I mean, her attorneys have got to make the argument. So I'm not knocking them for that at all. You know, they're gonna try, because it's a brand new law. So they are going to say, hey, judge, here's an argument as to why this should expand beyond defamation. But I don't think reading the statute and it's in, you know, knowing what it is intended, I don't think that's how it will read. Whether Lyman can argue, find a way, he probably will, but I don't agree with that. Okay, so Section 47.1 is not limited to defamation, but instead applies to the successful defence of the litigation. Yeah, of defamation, not of everything. Accordingly, apportionment of Lively's defence costs by claim is not permitted. I don't agree with that, because otherwise why are we doing all of this? Section 47.1's conferral of a fee shifting right to the recovery of fees for successfully defending in the litigation distinguishes Section 47.1 from other fee shifting statutes. Under California law, apportionment may be appropriate in other contexts, such as where a plaintiff has prevailed upon some claims but not others, or where a statute textually limits fee shifting to particular claims. For instance, in Griciano, the California Appellate Court evaluated the lodestar amount where the plaintiff prevailed on some claims for which she was entitled to recover fees pursuant to two different statutes: the Automobile Sales Finance Act and the Consumers Legal Remedies Act, which limit recovery to the causes of action brought under those statutes, unlike Section 47.1. The text and purpose of Section 47.1 do not support the use of the apportionment principles here. Section 47.1 entitles recovery for the successful defence of a litigation without any textual limitation to any particular claim. The text and structure of Section 47.1 is thus different from California's anti-SLAPP statute, under which parties may file a motion to strike a particular cause of action. Where a SLAPP defendant succeeds in striking some but not all claims, principles of apportionment may apply to address still viable claims. No such concerns apply to Section 47.1, where success is measured by the litigation rather than a specific claim. In the Wayfarer action, Lively succeeded in every conceivable measure. All of the Wayfarer parties' claims, which were brought as a strategy to sue her into oblivion, were dismissed with prejudice and abandoned without amendment or appeal. I mean, they weren't all dismissed with prejudice. 4 remained. The fact that Wayfarer did not, renew them that's their prerogative. That does not mean she has. That does not mean that she should get a free for all on the fees. Apportionment is therefore inappropriate under Section 47.1, given its broad statutory purpose of protecting good faith complainants. Like Lively. From the costs of retaliatory litigation. Can I just say, right, I've been working in law for 25 years. I have never seen a lawsuit with more bad faith than I have from Lively and her attorneys. I genuinely haven't. Lively is entitled to the recovery of full fees and costs associated with her prevailing defence of the Wayfarer action, as well as for fees and costs incurred in furtherance of that recovery, including in connection with this motion. I do agree, if she's entitled to the costs and fees in defending the defamation cause of action, not the full thing, I do also think she should be entitled to fees and costs in recovering those fees. So arguing Section 47.1 applies, and then, this motion specifically, then, this is how much we want back. What is bothering me, though, is there are no invoices. There is literally no invoices. Likewise, where work on recoverable and non-recoverable matters is inextricably intertwined, no apportionment is required. Here, Lively is entitled to recover fees and costs on work that is inextricably intertwined among her successful defence of the Wayfarer action and her prosecution of the Lively action through the Wayfarer parties' abandonment of their right to amend the dismissed complaint. Again, there's lots of references to this Cantor Declaration. There is no Cantor Declaration. There's no Cantor Declaration at all. I keep checking. We are well past the deadline anyway. Lively's attorney's rates are reasonable. Right, I'm going to have a lot to say about this. Can we just remind ourselves, right, that for a motion to dismiss from the same complaint, the New York Times are seeking $150,000. For filing to dismiss from 2 motions to dismiss in Texas, Lively against Jed Wallace, Lively is seeking $800,000. Okay, just to put all of this into context for you. Now, Leslie Sloan, I think it was 1.3 million. She was seeking again and I think that's extortionate, to be dismissed from the same Wayfarer complaint. Lively here is now seeking 7.5 million. That is incredibly bloated, right? And even with the furthest stretch of my imagination, I cannot get there. I can't get there, right? And I will be. I've looked at Gottlieb's actually his declaration. He says how many hours himself and other staff in Wilkie worked on the motion to dismiss, right? And I like break that down into how many business days is that, and it makes no fucking sense. Okay, it makes no sense. Okay, so yeah, attorney's fees sought in the amount of $7,495,526.87 are reasonable. I disagree. In California courts apply the lodestar method to calculate a statutory attorney's fee award unless the statutory authorization for the award provides for another method of calculation. Using this method, courts begin with a lodestar figure, which is calculated by determining the number of hours reasonably expanded, multiplied by the reasonable hourly rate, which may then be adjusted based on consideration of factors specific to the case in order to fix the fee at the fair market value for the legal services provided. A lodestar figure is presumptively reasonable. An hourly rate is reasonable when it is within the range of reasonable rates charged by and judicially awarded comparable attorneys for comparable work. To determine an appropriate range, courts are vested with broad discretion to consider a number of factors, including 1. The experience and qualifications of each attorney and paralegal who build on the case, 2. Rate determinations in other cases, and 3. Surveys of prevailing rates among similar attorneys. Counsel's rates are reasonable across each measure. And I'm not, again, when I looked at their hourly rates, yes, I could actually well believe that they are in the realm of, what is reasonable for law firms of their, kind of knowledge, experience, the quality, etc., etc. I have no, that bit I'm not questioning. First, the hourly rates charged by counsel are reasonable based on the experience and qualifications of Lively's counsel and standard market rates. A billing rate that is the usual rate an attorney charges for his or her services is evidence that the rate approximates the market value. As one judge in this district recently held in a case involving a Wilkie fee application, because the reasonable rate is what a paying client would be willing to pay for counsel to litigate their case effectively, the fact that the client actually paid the fees charged, as is the case with the fees sought here, is a strong indicator of the reasonableness of those rates. Here, Wilkie and Manat are international and national law firms, respectively. In defense of the Wayfarer action, nationally recognized attorneys Michael Gottlieb and Ezra Hudson served as co-lead trial counsel and assembled a team with extensive experience, including in First Amendment, complex legal commercial litigation, and employment litigation. All time billed to Lively reflects 10 and 15% discounts, and this is the discounted rate from Manat and Wilkie's standard rates, respectively. And I would expect there to be some kind of discount because there are obviously two clients that have come together as well. Law firms would normally give some kind of, discount for, referral or two people coming together. The average billable rates for each attorney for whom Miss Lively is requesting fees are addressed in the declarations of Mr. Gottlieb and Miss Hudson, respectively. I'll look at them in separate videos, in their own videos. Second, the rates are well within the range of rate determinations in other cases. Likewise, the court observed in PDV USA although in other geographical areas and other types of cases, the hourly rates charged to and paid by Wilkie's client may well appear outlandish in the New York City area. Comparable rates have been awarded as reasonable in commercial litigation. As further described in the supporting declarations, counsel's standard hourly rates are also reasonable and consistent with the prevailing rates among attorneys of comparable law firms. Third, the lodestar billed hours are reasonable. By and large, the court should refer to the winning lawyer's professional judgment as to how much time he was required to spend on the case. As further detailed in the supporting declarations, given the novel and complex employment and First Amendment issues that this case presented, Lively retained the two firms that specialise in those respective areas. And they delivered consistently high quality work that was detailed, thorough, and reliable. Accordingly, Lively seeks compensation for the $7,495,526.87 in fees billed. Again, still having references here to the Kantner Declaration. Here, but there isn't a Kantner Declaration on file. I'll have a look actually. Is there one? Exhibit A, Exhibit A, Exhibit A. Is there a Kantner Declaration? I am just checking again because if I've missed it, great, but I don't think Exhibit B, peer data. No, that's not. So I've looked, it says Exhibit B, but the Exhibit B is just peer firm data, which is basically a comparison of Wilkie's rates versus like other attorneys, you know. But there is no Kantner Declaration at all. Unless it's on Pacer. Let me have a look at Pacer. Sorry, I just want to... Oh! There is. Exhibit B combined. Oh my god, 174 pages. Are you kidding me? Right. Okay. I will download them and there may be a fourth video on this. Okay, so I take back there is a Kantner Declaration, Exhibit A. Okay, right, we do actually have yeah, we do have invoices. Well, are the invoices? We have a spreadsheet of all the fees. Okay. All right then. So I'll have a look through that. And see if there's anything interesting there. I might just do her declaration and just like a whiz through of her fees. Yeah, okay, I'll do that. I might. Yeah, no, well, I'll do Ezra Hudson, then I'll do Mike Gottlieb, then I'll do this Diana Cantor. Okay. Oh, so that's why no one can find it, because it's not on Court Listener, it's on Pacer, which means it has to be paid for. Okay. Given the context of this litigation, the approach of opposing counsel and Lively's complete victory on her motion to dismiss and 47.1 motion, this is an eminently reasonable amount. Further, given that Section 47.1 was recently enacted in 2023, it required extensive research and briefing for which there is little precedent. Right, I said this in my video where I said what I thought, my theory about how they were gonna, if they were gonna fudge the fees, how they would do it. And where I first said, do you know what, I think they could absorb Ryan Reynolds' fees into Blake Lively's. I said that basically, because the causes of actions that they were arguing in the motion to dismiss, most of them are fairly standard, right? Defamation, false light, invasion of privacy, civil conspiracy, and the intentional, the interference with contracts. These are not complex, right? They say in their declarations, oh well, the Wayfarer's complaint involved complex issues. It did not. But I did say, I bet they're going to say they needed a lot of time to research and put together a defense for Section 47.1. Sorry, not a defense, because that's where they first introduced it, was in Library's motion to dismiss. So they were like, oh, and by the way, we're protected by Section 47.1. I don't think it needed as much research, right? Because she's basically, all she's doing is asserting the law. The research would have been on Wayfarer, really, to like, all right, okay, how can we defend this situation? She literally, in the motion to dismiss, said, oh, you sued my client for defamation. It involved sexual harassment in the workplace. You're now on the hook for this. Gotcha. It was almost literally like that. So I don't think there was too much. And Ezra Hudson would have been, she serves on various boards and stuff that are associated with the people who wrote Section 47.1. But because it's a new law, I did say I could see them saying, well, we needed to spend so much money and so much manpower on researching this brand new law, which, and then just act dumb. Start playing the I'm clueless, I've got no idea, no one's ever dealt with this law before. Judge, you understand because you've had to rule on it, and I bet you had to do a lot of research too. I saw that coming. I don't buy it at all, but I could see where they could absorb additional fees. But I still fully believe that they have basically absorbed Reynolds' fees as well. I think that's what's happened, because I cannot, by any stretch of the imagination, get to $7.5 million. And if you imagine, this is why Section 47.1 is here. Because if the ordinary person who doesn't have a cool $7 million in their bank account isn't married to, one of the biggest movie stars currently, if it was an ordinary person like Victoria Burke, who didn't have that kind of money, where would you even start? And I know defamation is it's obscenely expensive. Even in the UK, to bring a defamation cause of action, you've got to go to the High Court, right? So you've got the Magistrates Court, which are the lowest courts, then you've got the County Court for civil cases, the Crown Court for criminal cases, they are higher. And then you've got the High Court. The High Court is, it's already high. You're looking at about £30,000 to even walk through the door with your lawsuit. You've got to do it within 7 months of the defamatory statement. So you've got to find that kind of money in a very quick amount of time. And that's before you even start any kind of litigation or, kind of discovery or that kind of thing, motions. That's just to, at the very start, you're looking at that kind of money. So defamation cases are incredibly expensive. I do get it, but I mean, just wow. $7.5 million, and that's just the attorney's fees. There are additional costs, by the way, of $539,514.01. Okay, so let's just wrap this up so I can get on to the next video. So there'll be 4 videos coming out today in total. This is the first one, the memorandum overall, which to me is just a PR hit piece on Wayfarer. just to throw shit at them for the last time, like a final hurrah. Further, given that, finally, even cases dismissed at the motion to dismiss stage may still involve considerable expenses, fees, and other financial and emotional harm stemming from attorney time defending them. This is particularly true here, where discovery was not stayed and was aggressively pursued alongside the litigation of Rule 12 motions. The discovery was not particularly involved. It wasn't particularly involved in Wayfarer's lawsuit against Lively. Again, this is where she is blurring and blending causes of actions. Lively would have had to have done that discovery for her own case. Is more likely to have needed the discovery for her own case, actually, than in Wayfarer's. Okay. Wayfarer would have been asking for the same discovery. Hey, WME, give me the text messages between, Warren Zavala and Ryan Reynolds. Because it would have been their defense in their case, in her lawsuit against them. So, and I think if you're going to pay them anyway, if you have to incur these fees as part of your lawsuit and your own lawsuit, Lively's lawsuit against Wayfarer, you're not entitled to fees, then you should not be able to, tack it on to a Section 47.1 award of attorney's fees and costs, reasonable attorney's fees and costs, because I don't think that is reasonable. And with that, that's me done. I'm going to move on to Ezra Hudson's declaration.